Jenny Sherlock, and Lloyd, my fellow West Virginian, I want you to know that the Lake Point Partnership for Selling Water is supposed to be with American Water. They're the folks that send the tainted water from the Elk River in West Virginia to all of our relatives in West Virginia, so not my favorite.
I took a course under her father.
My dad was a professor at Marshall University. Well, Donna's given me 12 minutes to speak, so I've broken my topic into 4 public comments. I only wish I could cram as much into each 3 minutes as Jackie Transinger, or Myra Delosi, or Henry Copeland, or Donna. Well, thank goodness Maggie Herchala has set out many of the issues related to litigating the Martin County difference in the materials that are available for you to give careful reading. For my 4 short comments regarding litigation to defend our urban boundaries, our rivers and estuary, our wetlands, our wildlife, and our quality of life, I've identified 4 types of challenges that the county is currently defending. The first is from what I call the quality of life deniers. These are the litigants who claim that our local government and our local government regulations cannot be used to protect and preserve our quality of life. This is what King Ranch and Becker Groves and Hove Grove and Lake Point argued in the challenge to amendments to chapters 1, 2, and 4 of our comp plan. They said quality of life can't be defined, it can't be measured, it can't be defended or protected. Seriously? I'll bet everyone in this room knows what quality of life means to Martin County residents. Let's see, everyone who knows what quality of life means to Martin County residents, raise your hand. Now, everyone who believes that our quality of life is worth defending, clap your hands together. All right, calm down. My second comment is for litigants who think the rules don't apply to them. These are the rule nullifiers. They're the owners of the Flash Beach Grill. They're the operators of the Lake Point Rock Pit. These are litigants who think someone else should provide wildlife habitat and preserve native vegetation, not on their property. These are the litigants who think someone else should protect our rivers and our estuary and our wetlands, not on their property. These are the litigants who think the rules that everyone else has to follow don't apply to them. But the rules do apply to the owners of the Flash Beach Grill and to the operators of the Lake Point Rock Pit. The rules apply to you and to me and to all Martin County residents and property owners. If we don't defend our rules, we have no rules. The third comment I have is for litigants who say they're entitled to break the rules because staff said so. That's the HM Property Investments litigation over the Martingale Commons project, which is an urban boundary buster. The developers in that case claim that they didn't read all the PUD documents that were approved and in place when they acquired the property through a foreclosure sale. But they said they talked to staff, and staff said they could do what they wanted to with the property. That's what the developers said. They don't want to follow the rules and the timetables for development that were previously approved, and they said a staff member told them they could do what they wanted. Of course, the staff member who they claim told them that is now deceased. He's not here to testify about what he really told the Martingale Commons folks. But even if he were, Florida law is well established that a single staff member cannot bind a county government. A single staff member cannot waive the rules for development, cannot authorize a project that is inconsistent with our comprehensive plan. In considering this very issue, one appellate court judge wrote that allowing a single unelected staff member rather than a majority of an elected commission to make rules or apply rules would be to invite all sorts of mischief. That's the word the judge used, mischief. Imagine a process that would require the county to honor a verbal commitment supposedly made by any county staff member to allow a developer to simply ignore or violate the rules. That's what the Martingale Commons case seeks to establish. That's an absurd conclusion that not only can be defended, but must be defended by our county attorney. Finally, my fourth category of litigants engaged in challenging the Martin County difference is the bully. That's the property owner or developer who says, give me what I want or I'll sue you. That's the Avalon Ventures litigant who demands maximum density zoning on property on Federal Highway and Sea Branch Boulevard and refuses to budge or give up a single unit despite vocal opposition from surrounding property owners who want to preserve the character of their neighborhood. Give me what I want or I'll sue you, he says. That's the Lake Point rock pit operators who want to force the county to let them do whatever they want without regard for our comprehensive plan or our land development regulations by suing and trying to bully government agencies and Maggie Herchala. They have seemingly unlimited money to spend on the litigation and to recruit vicious anonymous emailers and giveaway newspaper publishers to disseminate their bogus arguments. The bully is All Aboard Florida, who wants, well, I'm not sure what All Aboard Florida wants, but it's clear that the economic viability and, yes, the quality of life for Martin County businesses and residents are entirely irrelevant to the All Aboard Florida plan, whether that's to increase freight train traffic or to actually run 32 high-speed passenger trains a day through the Treasure Coast. We have to stand up to bullies. We have to defend litigation and legal challenges or risk becoming a target for every politically connected or wealthy bully who believes that quality of life means private profits and that the only green that matters is money. Our new commission, elected in 2012, inherited more than potholes and crumbling bridges and a gutted comp plan from the old county commission. There are currently about 50 active litigation and pre-litigation cases involving the county. Now, some of these are negligence cases, injuries that occurred at the Sailfish Splash Water Park or Indian Riverside Park or on other county properties. The county has insurance coverage that pays for the defense of these types of claims. Some of the cases are eminent domain cases that are handled primarily by state agencies. Some are construction defects cases, like a dispute over the play surface that was installed over at the Jensen Beach Elementary School, or the failure of a developer to install infrastructure at Port Mayaca Plantation before going into foreclosure. There are animal control cases, and there are state rule challenges and long-standing litigation like the Lamar billboard case. And there is, of course, the legal fight over the management of the St. Lucie Inlet. The county attorney's office handles much of the litigation, but needs outside help to adequately represent the interests of the county in major litigation like the Lake Point lawsuit and the comp plan challenges. I've set out some of the costs associated with these matters in a handout that you all have with your materials. This sets out the cost in outside counsel fees and compares it to some of the costs of other matters that the county pays for, such as building a mile of the Green River Parkway. One lane, $2.7 million. It's inescapable, the defending litigation commenced by the quality of life deniers and the rule nullifiers and the bullies costs money, costs a lot of money. But at the end of the day, for Martin County citizens, the real question is not whether we can afford to preserve the Martin County difference, to defend our urban boundaries, our rivers, our estuary, our wetlands, our wildlife, and our quality of life. The real question is, can we afford not to? Thanks.